Hey,
Good morning.
It's canceled.
Cancel. Oh, yeah, because I signed the order.
Okay, and here's the other one, cancellation on 15/203/88.
Hold on, let's see.
203/88.
Okay,
Thanks.
all
Thank
right,
you.
good, thanks. Number 6
Number
is
13.
fine. All right. Yes, 13?
Michael Brown, on behalf of the defendant, George Martinez. In this case, Judge, on the 20th of March, he opened up a bankruptcy. So we'd be asking the judge to take this off calendar for that purpose due to this bankruptcy stay. 13.
All right, who's on the other side of that case?
It's Carlos Gil, PA.
All right, and do they know about that?
I imagine they do. They're not here, and this is their motion. I just want to let the court know.
Okay.
Do you want the
All
bankruptcy
right.
case number by chance, or?
Please.
Sure,
and-
it's 17-13342 AJC.
Oh, Judge Crystal.
Yes, sir.
Okay, all right. Do me a favor, fill out a blank order that says, this case is stayed,
Sure.
do the bankruptcy and put the case number in it, and I'll
Okay.
sign that. Okay,
Thank you.
thanks.
Number 8.
All right. Number 8.
Good morning, Your Honor. We're scheduled for trial on June 30th. This case has her son is getting married in Kentucky on that day. So,
Yes, no, I read it. I'm granting it. It's going to be continued until August 11th.
August 11th.
And I want you at 10 a.m. Okay?
Okay.
So,
The only request we had was that it be specially set, because we're looking for about 2 hours. So I don't know if that's a special set you're gonna set it on, or
at 1:30.
1:30?
I'll write that in.
August 11th at 1:30.
August 11th,
Okay?
1:30. Thank you, Judge.
All right, I want you taking a copy of this to Tanja as soon as I sign this order, though. Okay? All right, thanks.
Sir, please go. Judge, this is the add-on that I'm putting you.
Yes.
Case number 2015-25-771. Are
Yes.
you up for that case, Premier? We have a court reporter.
All right, we're here on Wilmington versus Kelowna, 15-25771. Let me have appearances, please.
Scott Goldstein on behalf of the plaintiff.
All right. good
Chuck
morning.
Throckmorton, defendant Kirsten Kalana.
All right, good morning.
Good morning, Your Honor. I have a copy of the motion for summary judgment if you'd like to see, Your Honor.
I have it. I've
Okay.
read it. I've read the response. I'm ready.
Okay.
All right. Go ahead.
Well, you can see from our motion that our complaint was filed on November 4th of 2015, claiming a breach date of February 1st of 2011. Our MSJ with all supporting affidavits were filed on November 18th of 2016. The big issue in the case is that we have a lost note here, and defendants claim that Wilmington Savings Fund never received ownership of the note, mostly because an assignment of mortgage from Chase, who took over from the FDIC from Washington Mutual, the AOM from Chase to Bank of America, who was intermediary, does not specifically reference an assignment of the note. But logically, you can't have a mortgage without a note. The note creates the obligation for repayment, and the mortgage creates a lien on the property that's secured by the note. So a transfer of one is a transfer of another. The mortgage and the note follow each other. And plaintiff has attached to the complaint a copy of a lost note affidavit signed by Saline Finance, who is the servicer for Wilmington Savings Fund. And that lost note affidavit incorporates a lost note affidavit from Chase, who lost the note when it was in their possession. And the affidavit from Chase explains the manner in which notes are kept in their safe, and it goes through the business records exception. The affiant says he's a custodian of the collateral documents. He has personal knowledge of what happens and what happened in the situation. That a diligent search was made, and the note could not be located. Defense took a deposition of my client, Mr. Fox, who was there to speak as to the lost note and some other issues in the case. again, a big issue that borrowers will raise and have raised is that Mr. Fox generally mentioned that transfers from Washington Mutual that went to the FDIC and then to Chase or to any other party, there were some issues that existed in a general nature on some cases. He said there were situations where Chase did not actually receive physical possession of the note. He did not go so far as to say in this specific case he knew that that occurred. He did not say that that instance occurred in this case, and plaintiff is relying on the affidavits of Chase, which are much more specific and by a person with knowledge as to when and how the note was lost. That's the big issue in our case. There were three.
So his argument is that creates a genuine issue of material fact, and therefore we ought to go to trial, really.
That is absolutely correct, Your Honor.
So-
And we took the deposition of one of the borrowers also, in terms of, she said that she couldn't specifically remember receiving a copy of the breach letter, but that she probably received a copy of the breach letter. She also stated that when payments were being made, which is only the first year of the loan, that she was generally making them and that payments had not been made in a while, and to her recollection, they were not made. The breach date of February 1st, 2011 seemed somewhat reasonable to her, and she could not remember making payments from that point forward. And so plaintiff is asking for judgment in its favor. Also, the affirmative defenses are standing, which I've discussed. Statute of limitations, we filed within 5 years, and res judicata, and this breach date differs from a 2008 breach date. So res judicata does not apply in these circumstances.
Okay, Mr. Throckmorton.
Morning, Your Honor. Judge, this morning we're traveling on the standing defense only, and what my colleague said about the law is wrong. It is not the law that the note follows the mortgage and that an assignment of the mortgage automatically transfers the note. We've cited cases that say that's absolutely not the case, and there are plenty of reported cases where foreclosure failed for want of standing, where all they had was what this plaintiff has, which is an assignment of mortgage that does not include an assignment of the note. May I approach, Your Honor, because this one-page chart shows the several factual issues in the chain of title to the note. You start with the original note, and it is lost. The copy that they attach to the complaint and to their summary judgment motion has an undated blank endorsement, so it could be out there anywhere. The second step in the chain of title that they claim under is that supposedly Chase, as a receiver, purchased the property from the receiver, of the original payee, WAMU. There's no evidence of that. There's no document that shows how Chase got the note. No assignment, no transfer, no endorsement.
So you're saying that even at trial, you win?
It's possible that even at trial, based on, if we were going to trial today on this record, I would win. But the crucial step so they don't have proof that Chase got it, and their own witness testified that he doesn't know if Chase even ever got possession of the note. But even if they did, there's no evidence whatsoever that Chase ever assigned it to Bank of America. And Bank of America is their assignor. So it breaks down at every step of the way, and there is doubt in the chain of title at every step of the way. And we've cited the relevant cases in our memo, but they can't show that their direct assignor, Bank of America, ever received either the note itself or the right to enforce the note. And in a lost note case under section 673.3091, you can't enforce a lost note unless you can show that you received the rights to enforce the note from someone else who had the right to enforce at the time, had possession and the right to enforce the note at the time of the assignment. They do not have that. That is not in this record, and their witness admitted it, Your Honor.
Well, I'm not sure I agree with you. Well, let's see what happens as far as the time of trial is concerned. But I do agree that there's an issue here. This ought to be set for trial. I'm going to ask, has the discovery been done, completed or not?
Well, that discovery is another issue, and we had a conversation this morning before the hearing that if we go to trial, then we would need to have the deposition of Chase, which is the one who supposedly lost the notes, so that, we need to do that.
Okay.
And Mr. Goldstein agreed with that.
All right. What's the August date again? We had it on the last order. August 11th at 10 a.m. I'm setting this for trial. Okay. I want both sides are now on notice. There's nobody else involved in the case, correct?
Correct.
Okay. Get whatever needs to be done. You know what your issues are.
Yes, sir.
You know what you need to do as far as depots are concerned. So please get that done, and I'll see you all August 11th at 10 a.m.
Thank
Thank
you.
you, Your Honor.
Thank you.
Number 7,
Good morning, Your Honor. Jessica on behalf of the plaintiff.
Morning.
This is our motion to vacate the final judgment and dismiss. The matter has been resolved, so we're asking.
So I read it,
Thank you, Your Honor.
signing it. Okay, great.
Thank you very much.
number 1, Giselle. Okay, please go ahead.
Good morning, Your Honor.
Morning.
Giselle Hernandez on behalf of the plaintiff.
Good morning, Your Honor.
All right, good morning.
Good morning, I'm Marilyn Prieto, the owner of
Okay. All right, now, well, let me hear from you. I read the materials that you submitted, but let me hear from you briefly, please.
I had a buyer. I had put my house up on the market because I wasn't going to be able to pay for it, and I realized that. So I put my house up on the market. We had a buyer who is fully approved. We were ready even to close back in November, fully approved. The bank willing to had a check to give for the full value of the home, and the title company would not lower the payoff so that we could all win. We could all sell the home. The new buyer gets their home. I get to move on with my life, and the bank gets the value of the home. So they're continuously, I have emails attached to this of all the times where they continue to ask me for more documentation, my pay stubs, my W-2s, and I submit everything to them continuously over and over. Up until yesterday, I sent them a letter explaining to them that my children do not participate in paying the bills of the home. A couple of weeks ago, I had to send them W-2s and pay stubs, and I find out today that the short sale was denied. But if the short sale was denied, why do they keep asking me for more documentation? And I comply every single time. And I have a buyer she's still waiting. She's still waiting to purchase the home and give the appraised value of the home.
All
She
right.
just wants her home, and I just want to move on.
Okay, all right. Let me hear from you.
Your Honor, basically, I just want to inform Your Honor something. The notice was not sent out. The property was sold to a third party. They were not noticed today. But either way, we are objecting to the motion. There are no legal grounds to vacate the sale raised in the motion. In addition to that, the short sale was reviewed, Your Honor. There was a denial letter issued to the defendant, was sent out to the property address on February 11, 2017. And
I'm assuming there's a deficiency.
there is a deficiency, yes.
Is your client going after a deficiency judgment?
Your Honor, that I know of, there was no agreement otherwise, so they may be able to. They do have the right to do so, but there was no agreement entered in the final judgment with the defendant otherwise to not go after the deficiency.
Were you present at the time of the,
No, sir.
The final judgment was entered on December 21st of 2016.
No, sir. I was not notified of the court hearing at that time, no. I requested this court hearing.
all right, then here's what I'm gonna do. I'm gonna put in the order, the motion's denied, okay? But I'm gonna put in the order, put in the order that the court, under the circumstances, is not inclined, we'll keep an open mind, but it's not inclined to enter a deficiency judgment should one be sought. Okay? Under the circumstances, I want you sending that order
And
to
the
your,
reasons for that,
to
Your
your,
Honor, just so that I
to your
could
client,
explain
based
to my
upon the fact that they had that the title company was the one who held it up and would have had a sale, which there would have been no deficiency judgment therefore entered, And under those circumstances,
Well, Your Honor, the short sale was not accepted
I
by
understand
the
that.
bank because of the amount of the short sale. And we sent the letter prior to the foreclosure sale denying
but the short sale
sale.
amount was more than the sale that went through, correct?
That I know of, it was a short sale.
I believe the difference was only $30,000.
There was a difference. It was a short sale.
It was
Your
only a
Honor.
$30,000
Well, that's why I'm
difference.
saying, you know, I'm not inclined to. Probably what you're looking at is maybe getting if you were to go after a deficiency judgment, the max would probably be 30.
Do you have a copy of the
So-
short sale, Your Honor? I would
so-
just like to verify the amount because I don't have a
Right.
copy of the short sale here. I would like to do it in front of the court.
I do
Do you remember the amount of the contract?
The value of the home was $198,500.
No, not the value, the short sale contract.
225.
Well,
It's
let's
$30,000
let's
over.
put it this way. You know, just go ahead, do the order denying it.
Okay.
I know that she's going to be here if there's a
If there's a
deficiency
deficiency.
judgment that
Okay.
is sought. And you will remember what everybody has said and what happened here in court. I'm not worried about that. So you will be here because deficiency judgments are going to be against you personally, or the attempt would be. So.
Correct. And I'll make sure
but
my
at this-
client is
But
aware
at this
as well.
particular point, legally, there are no grounds for me to vacate it and set it aside. Okay? So, you know, I have to, as a matter of law, follow the law, and I'm going to do that. All right?
So how long
But
do
I'll
I
take.
have in my home? How long do I have in the
That
home?
That's a
depends on
good
the third
question.
party.
The third party bought the place until they get a writ of possession, which they haven't gotten yet. You know, but you don't have long, I will say that. You know, so please, for your own sake and the family's sake, make other arrangements, okay? Because it is going to happen, all right? Okay, thanks, Mr. President.
Your Honor, I have an
Yes, sir.
order.
Okay, great, thank you.
Sir, you want to give her any paperwork? Yes.
Is the other side still here
Yes.
or not?
Yes, Your Honor.
Okay, have you guys talked about the possibility of a conciliation conference between now and prior to trial or not?
We have a,
I mean,
a
not
very
mediation,
good
because mediation is
right.
expensive, and I'm not looking to saddle anybody with that, but conciliation, at least the bank people that have the power would be involved in it or not, so I don't, you know.
We could
that's why I
certainly
was-
try. We have a good relationship, and we've talked, and offers have been made, and
Okay.
We've been doing a pretty good job at that process between the two of us, and
Oh,
it's just a
okay.
question of getting there. I don't think we need that extra layer.
Good, okay.
Because of we've been working at it pretty hard.
Mhm.
Okay, all right, great, okay.
Thank you.
Right.
Thank you, Judge Thornton.
Yep, all right.
Okay. What is this? Yeah, we'll do this for you.
All right, Arturo,
Yes, sir.
what's next?
Do you have a copy for him?
We're just getting started, I mean, come on, where's the rest of the,
You're all
I mean, all dressed up and no place to go, I mean, you know.
You want, sir, do you want me to confirm the copy?
If you don't have enough for me to write, it's okay. Just email, scan an email.
Okay, all right. Is this yours, sir?
Yes.
Thank you.
So, were you here yesterday?
Yes, I will.
All right, so, any difference between, you know, this and the, you know, and